आपने बेशक चांद को देखा होगा, मगर क्या आपने चांद को कभी ढलती हुए देखा है?
अगर नहीं तो चले आइए गुजरात के मूनलाइट समान सफेद रण में और शामिल हो जाइए इसके भव्य उत्सव रणोत्सव में। साथ ही एक्सपीरियंस कीजिए मन को मोह लेने वाला रोड टू हेवन जो बनाएगा आपके सफर को और भी खास। आज ही बुक करें रणोत्सव द टेक सिटी के साथ। बुकिंग्स के लिए विजिट रणोत्सव.net या कॉल करें 1-8
My lords, that being spoken to your lordships allowed the writ petition 2 days back. Now the KEA is telling the candidates petitioners also that they have to, they are not allowed now because they were private quota seats were allotted to them, which they moved this honorable court. That's saying they are eligible for government quota seats. That's why they came before this honorable court. Now they are saying you go back to your colleges where we have already allotted. We will see later. Therefore, my lords, this direction may be issued because this honorable court has already passed an order to allow them to participate. Still, they are not allowing them.
Should it not be a fresh cause of action then?
No, for the
If
same
after
petitioners.
yes, the very same petitioners, after disposal,
Yes, my lords.
if they are giving an interpretation to the judgment,
My lords.
should you not move a fresh writ petition rather than a,
Yes,
because
yes,
we have said
yes, my lords.
if it is an interpretation, then probably a fresh writ petition
Yes.
may be the better option.
Any mentionings? Please.
Serial number 13.
My lord,
This
serial
one?
number 2, my lord.
Page 1, serial number 1 to 4.
My lord, serial number 2. I am for the
Yagachi
respondent.
Yagachi
My lord, my lord, my lord.
Same,
May I
same
make one
notification.
request, my lord. Kindly have it on Wednesday, my lord. My lord, I will do my submission, please, my lord. I will file my judgments and I will try to convince my lordship with regard to this, my lord. I am outside. I am out of town, my lord, for some emergency reason. For that reason, I could not come today, my lord. Wednesday, my lord.
Yes.
Please, please.
At the request of Prashant for installments.
But item number 1 is the same notification. That will
No,
be discussed.
may I submit, my lord?
What about item number 1? What about item number 1?
I am not party, my
Don't
lord.
say
In
Yagachi. Yes, we'll
I am
see.
not party.
Page.
Yes, Wednesday.
Good thing you would have rejected your applications and disposed of the appeals.
Yes.
2, serial number 5 to 8.
Serial number 5. This matter, my lord, was listed yesterday.
TRC, relinquishment, road widening.
But today I have some.
Yesterday to
Lords
today.
can have it.
Today only at your request it is listed.
Please, my lord.
I think today it was
Yes,
requested on
yesterday,
your
my
behalf.
lord, it was listed for today. Yesterday I sought for a passover, my lord, but however, at the instance of respondent counsel, it
Let
was
he is
posted
not
for-
there.
Today I have some personal inconvenience. I have intimated the other side also.
You've informed.
I have informed,
Monday.
my lord. Kindly call this next week, my lord. I will go on
Monday,
with the matter.
Tuesday.
Yes.
Today.
Any day next.
Please, much. I'm sorry, my lord.
13 to. Page 3, serial number 9 and 10.
Hmm.
2,753 days delay.
Is a grantee or not?
753 days delay.
Same now.
Same.
Last time also did. Last date also it has come, no? Once we have granted time.
Mm.
Date code. At the request of land council for the respondent. List on.
19 to. Page 4, serial number 11.
CM 11, my lords had adjourned it by 4 weeks. I don't know how it is listed. Early hearing application, I inquired, my
yes,
lords,
yes.
is not filed by appellants also.
Done. Barkodi. ಇದೆ ಅಲ್ವಾ same matter, not before me.
My lords had simply said 4 weeks, my lords, with a conscious.
Wait, can you wait for a minute?
Please, my lords.
We are passing orders, no?
Please, my lords.
Sometime it happens mistake.
No, my lords, my lords, I consciously said 4 weeks, my lords, not before me is not necessary, is my submission, my lords. Let it be adjourned, my lords.
Barkodi. List before the bench where VAP is not a party.
Yes.
Yes.
Page 5, 13 and 14.
Serial number 13, lordship.
After obtaining the orders for the bench list.
Serial number 13, lordship. Praise a week time for argument.
Plenary hearing,
Senior
legal-
not feeling.
What
with
is this
lordship.
about?
For argument, lordship. Argument, lordship.
13.
Praise a week time, lordship.
What is it about?
Senior not feeling well, lordship.
Hmm.
My lord, 23, I am appearing for respondent, my lord.
Please wait, counsel.
Please.
Reduction of the percentile, my lord.
The same thing.
There are no seats available.
The first today order, same thing will apply.
Bachelor Unani Medicine Surgery. Item 13?
I think this is, against the interim order you have come,
No, that is.
Serial
that is
number
another.
13, Raj.
No, no, that is item
that is
uh,
6.
6. 13 is not that. 13 is,
We will see, so wait,
please wait.
wait for a few minutes, we'll see.
Please be here. Yes.
We are not read that, we'll see the order set and consider it.
Page 6, 15 to 17.
Serial number 15, your lordship.
Serial number?
The cause this, your lordship, the cause this, it has shown the.
Serial number?
15, 1 5.
But you have to wear that, whatever band, collar,
Yes.
you don't make submission, we will not allow, we will
No.
not consider.
No, your lordship, that.
No, no, we will not allow. If high courts are started allowing entertaining such things, we will not. Make a request to your colleague, whenever matter reaches, you should come in proper attire, we will not entertain anything such.
His white shirt.
Will not.
White shirt only.
Whatever may be. That is not the proper attire as per the bar council. We will not entertain that. Please don't do that and don't oppress us also and yourself also. Don't make mention. To ask somebody to make a mention, we'll consider that whenever it reaches.
Page 7, number 18 and 19. Page 8, 20 to 24. Page
My lord, 23, my lord. My lord, there is some inconvenience to me, for me, my lord. 23, 24 and 25, my lord. My lord, 13th, my lord. Same, Wednesday may be taken.
All these matter are same accusation, huh?
No, my lord, different equation, but they are telling that 1 lakh has been paid. My lord, I will try to convince my lordship, my lord, with regard to this.
All right, Yella, Budhvara, Wednesday.
Or on
Wednesday, my
Wednesday.
lord. Please, my lord,
Yes.
Wednesday. Please.
12
Number work on 23.
23, 24, 25, and
25.
along with item 2.
2, my lord.
Serial number 26 to 28. Page 10, 29 to 32.
29, my lords, for respondents. Press time.
The appellant in the same case, my lord, serial number 39. Senior counsel is engaged in this matter and he is not available today.
Press time.
2014.
But it will be fixed, my lord.
Paper book received, huh?
Have you received the paper book? My lord, earlier when the paper book was filed, it was filed in the counter.
Not received.
On filing of acknowledgement for having served the copy on the respondent, whether your respondent received or not.
No, not received.
I'll give a.
No, everybody, ಅಲ್ಲಿ paper book.
Illa.
That's the joint request, list on signs.
Serial number 30, my lords. Serial number 30, my lords. I'm the proxy counsel for the appellants. Counsel
27.
on record has gone out of station, is unwell, my lords.
Have you informed the other side?
I am for the respondent.
Hmm.
So every time
Can
they
we
are,
From the other sides, my lords.
any short possible date, if my lords may consider fixing, please.
My lords, 3 weeks time may be given. Any date may be fixed, my
Why
lord.
3 weeks? It's a 2014.
My lords, it's a medical emergency. He was traveled last evening, my lords.
Okay.
Yes.
At the request of the learned counsel for the appellant. Mr.
5,
But date
3,
after 3
5,
weeks.
3.
5-3.
Please, my lords.
Page 11, 33 to 36.
My lord, appearing for the serial number 34, appearing for the respondent. My lord, senior counsel is gone for the brother's marriage, my lord. Kindly matter may be taken on,
Requisition.
posted for
BSc
Monday, my
legal
lord.
private.
Date given, today is date given matter. Alva,
My lord, he is gone for the brother's marriage, my lord.
Eh?
By Monday, he is ready to,
Have you informed the other side?
yes, my lord.
You have.
Yes, my lord.
yes, at the request.
13
of
to-
respond listing, list on signs.
13 to
Much obliged.
this 2. Orders, number 1.
The
to
respondent state, my
inter-alia.
lords.
69-year-old man. Any news?
Lord, we are also unable, all efforts have been made, including publishing photos in the.
Did he have any issue with Alzheimer's or anything of that sort?
No, madam.
69. No,
16, no.
he was perfectly,
normal, it was normal.
no difficulty.
No, any ailments. Dementia is what
Dementia is what we are asking about.
his brothers in Chikmagalur were interrogated.
Huh.
All his relatives were statements were recorded.
Nobody is heard of.
Nobody is aware that he has reached there.
69-year-old, it could be that. please ask him whether there has been any
This is the first time it has happened, my lords.
stem going away, we understand. That is
Yes.
not what we are asking. Was there anything concerning, maybe
Depression, my lords.
no, difficulty to remember how to do things that he normally did?
That's-
That is how,
At para 7, they have stated
Hmm.
that he suffers from impaired memory loss.
this is what we are asking. When you say that that is so,
Para 7.
Yes, ma'am.
impaired memory,
No, unable to identify the roads, my lord, because he's from a village.
No, no, no.
Unable to identify the roads. That is, the-
impaired
suffering
memory is
from
what you say in
impaired
your
memory loss.
petition.
yes,
A 69-year-old person,
yes, ma'am.
there's every chance that he could have wandered off.
Yes, ma'am.
The nature of the investigation changes if you please disclose whatever is the actual situation to them.
Let's that, whatever I have stated is correct, my lord. He has little, his identification of the roads is a little difficult because he's from a village.
This is on 31st.
Yes.
Would there be some CCTV footages available?
My lord, I'll place the report, my lord. All those things in the investigation have been carried out. And I'll place the report. my lord.
Nothing has been found.
Nothing has been found. The footages show that he's going somewhere.
Hmm.
After that, he returns,
Hmm.
then we lose track of that because the connectivity is not there. So all this we'll place on record.
Hmm. Yes.
You file,
Let them place it
let
on
them
record.
file whatever they have done, we'll examine that, whether they
Very
are
well.
properly.
And if you have any information, please ask
Please
your
share.
client
Cooperate, my
to
lords. Every-
cooperate
then
completely.
For IO, they have given the information.
Has he been interrogated?
Yes, all of them. Yes.
Whether he has phone number, mobile number.
No, he's not carrying it. Sir, just recently, 2 months before, he has come to Bangalore, my lord, from Chikmagalur.
ಇಲ್ಲಿ ಎಲ್ರು ಇರ್ತಾರೆ ನೋಡ್ ಅಂತ ಹೇಳ್ರಿ
Some
ಅವ್ರಿಗೆ.
ಅಂಗಡಿ ಹತ್ರ ಹೋಗಿ ಮತ್ತೆ ವಾಪಸ್
Where maybe in Bangalore, he may be missing. That also villager, no, he may not be knowing. Let them
But then-
seriously make some effort.
Yes, yes. We'll make.
Please, may not have gone outside the Bangalore or something.
ಇಲ್ಲ
He
ಇಲ್ಲ
may be-
ಇಲ್ಲೇ ಎಲ್ಲೋ must be.
If there is
Duty-
some memory impairment, he may not be able to
Recognize-
communicate also and come back.
But
So
for this
difficult.
long, he cannot be wandering here and there.
Somebody would have.
Somebody could have
heard of
seen him lost somewhere.
There are chances of somebody would have taken to some old age home, joined him.
No, we
That is
checked that
important.
also.
They have to check
Yeah.
the old
ಅದು
age.
ಮಾಡಿದೀವಿ. Old age home check ಮಾಡಿದೀವಿ.
You have
Yes, yes.
Bangalore,
Yes.
so many are there. Whether they
Yes.
have checked all, maybe.
Yes, yes.
hospitals.
We will, not in city.
Hospitals also.
Hospitals will check.
Maybe somebody has taken him there.
Yes.
Learned SBP submits that earnest attempts are being taken to trace the missing person and that a status report will be placed on record. List after
2 weeks, no? 2 weeks.
Great.
Any first? Number 2? Veda?
For respond number 4, the husband.
11-month-old child was 9-month-old child.
9-month-old.
Yes. Now back to mother, my lord.
Where was she? Where was the child?
With respond number 4, the husband.
I am appearing for the petitioner in this case, madam. I have certain submissions. I'll do it after.
I am filing for respond 4 and 5 minutes.
Yes,
Husband and mother.
whatever that be.
No,
What
that
is
is-
this?
Without intimation, how?
Taking the child away for what,
No, no, no.
whatever your reason.
In fact, that is even the petitioner mother has handed over the child. In fact, there is a dispute, even they have settled before the Jamaat also, to live peacefully.
How child, why you took the child?
No, in fact, the petitioner mother has given to him.
It's a false submission, my lords.
Internal
Sorry.
dispute, we don't know, in fact. The petitioner mother herself given to the petitioner, respondent number 4.
Hmm.
And ultimately filed a petition before the Salco.
We'll not go into all this. Now the
Child
child
is
is with
back.
the mother.
Yes.
Child is back, madam.
I have submissions, my lords. Before making orders, I want to make certain submissions before this honorable court. Actually, it is the inaction of the police, my lords. When the child was missing, the petitioner approached the police station and the police made a fool. They made a joke of the child, of the mother, and they did not take the complaint. If they would have taken the complaint and filed a FIR, this
Which police station did you?
Jayanagar police station, my lords. If the police would have taken act, my
When
lords.
did you go to the police station?
Just 2 days before the filing of the petition, my lords.
No, she has said that he is being petitioned.
Huh? Okay. Okay, please shut down shut it.
Close that. Stop that live.
Nothing of that seems to be covered in the petition. Notification, I think it is different.
Notification is different.
Let's
This is
also.
2012 notification. In your case, it is 2009 notification.
Very good.
Final notification in 2011. Notification is different here. The Nigam is also made a party.
Prior to this. Look, I definitely apply this because this notification in subsequent delays is 2009.
No. In our case, it is 2009. What we are,
So,
no, it is 12.
yeah.
Okay. 9, same notification. Oh, it is, yes.
Acquisition
Correct,
for the same purpose.
correct. LAC 85, 86. Yagachi Reservoir,
Yeah, got
Same.
it. Yes, ma'am. Same project.
4/2, 2009, 16/11, 2000. Here it is.
This is not, they are not challenged this, huh?
Not challenged.
This is not challenged, my lord.
Here also 1 lakh.
Hmm,
1 lakh, no?
We've already given 1 lakh. 3 cases were given.
Yes, I'll pass.
Mm.
Yes, dispose of. That's it.
For the respondent, my lord, I want time to file the objection, my lord. That accommodation may be given, my lord.
Termination of service on account of criminal case.
Please, my lord.
Acquitted in the criminal case.
Admitted.
Directed to be reinstated.
He-
The contention is that post is abolished.
He abolished his, we have appointed him on the basis of a contract, my lord. His tenure ends in the year, on the 1/31/3/2019. His tenure ends.
Hmm.
So the question of reinstatement does arise, my lord.
What happened to all the other employees that you had engaged on contract?
All of them are terminated, my lord.
Where is the,
The document, additional document, my lord. The letter written by the
yes,
separate IA we have filed in our document, my lord,
but then.
at page number 98, my lord. His tenure ends.
I will file my objection, my lord, to that accommodation.
Yes,
Not objection.
to this IA.
No.
Please, my lord.
At the request of the council for this form.
Much obliged.
Show cause notice.
Yeah.
Show cause notice.
No, my lord, it's a notice issued by the admission overseeing committee alleging excess fee, my lord. May I seek a pass over, my lord,
The order also says that excess fee was collected by you in the previous year and which was duly refunded by you.
Yes.
So that has been refunded. I have not collected the excess fee. My respectful submission is, my lord, there is no determination of the fee at all under the act. So what the government is saying, my lord, what the committee is saying that I have collected more than the tuition fee. And their contention is that I should take only the tuition fee, not anything more than that. My respectful submission, my lord, that would run contrary to section 7 of the determination of the fee act, where the section specifically specifies that there has to be a determination for each institution, and this determination, my lord, is institution specific. So in my case, my lord, there has been no determination.
Who determines?
It's the fee regulatory
Committee.
committee that has to determine the fee.
Not happened.
It has not happened, ma'am.
Then is, what is the circulars issued by the government would be applicable under the act?
My lord, my respectful submission, my lord, is the government cannot supersede the section 7, my lord, by way of the circulars or the notification. In this case, my lord, if my lord sees my prayer, may I seek a passover, my lord?
Government
Passover.
notification dated so and so. Also. Wait.
Admission not through KEA. Admission not made through KEA. Interim prayer rejected.
Yes, ma'am. Against, my lord,
KMS.
what had happened was our my lord, the last date for admission and last date of counseling, my lord, was in September. We got, my lord, the permission, my lord, affiliation, my lord, in December. And my lord, if your lordship look at, my lord, the order, the consensual order, any, my lord, seat, my lord, which is not filled up, please come to, my lord, running page 74 of the writ appeal.
Yes.
My lord, this is a consensual agreement with the government.
Yes.
It starts at, my lord, page 65.
Hmm.
At 74, if your lordships come to, my lord, D.
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 Yes.
Is further agreed that there shall be 2 rounds of counselling and 1 mop-up round, and after this, if any seats remain unfilled, or stray seats, if any, fall vacant, would revert back to the government professional colleges foundation, its member institution for filling up the vacancy. My affiliation,
What is the date of this
my lord, this is, my lord, 2000
consensual?
Annexure C, my lord, page 68. Date ಯಾವ್ದು ಇದು?
223. This is with regard to 22-23?
Yes, yes, ma'am. Please come to my lord, date your lords at page 76. 4th of October 2022, my lord. Page 76.
State Common Entrance Committee for the purpose of review of the admission.
We have a neat eligibility, sorry.
Yes, you are the students.
My lord, we are students, my lord, we have neat eligibility. Please come to page 50 to 59. We have passed, my lord, the neat examination. We have, my lord, the eligibility.
Counseling by KAA shall be conducted as per calendar of events stipulated by the regulating authorities, NMC and affiliating university. In the event of a conflict variation in calendar of events published, calendar of events mandated by the apex bodies or orders of courts would prevail. It is further agreed that there should be 2 rounds of counseling and 1 mop-up rounded after this. If any seats remain unfilled or stray seats, if any, fall vacant, would revert back to the Karnataka Professional
Where is
Colleges
your
Foundation
affiliation?
member institutions for filling up the vacancies from the list of unallotted students furnished therein in the KEA portal. And if such students are not available, then KPCF, its member institutions, shall fill up with students eligible, qualified in the
Permission is on
It must be through unallotted students furnished in the KEA portal.
My lord,
You have a case that no such students were available in the KEA portal?
no, my lord. What had happened is our affiliation itself came on 7/12. My lord, please come to page 77.
No, whatever that be. Even the unfilled seats have to be filled up from the KEA portal only.
My lord, KEA, my lord, mop-up round also, my lord, was over. Before, my lord, we got our affiliation.
Even so, then you could not have admitted.
My lord, admission is, my lord, up to September, my lord, March. Please come to, my lord, running page. If your lords come to, my lord, page 79. 77, my lord, is my affiliation. Please come to, my lord, page 77. 7/12/2022. I got the affiliation. Please come to, my lord, page 79.
Yes.
4/3/2023, my lord, is the last date of admission. The admission fee payable, my lord, is 6/3. 13/3, my lord, is getting admission register. Last date for submission, my lord, is 27/3.
Just a moment, please.
Sorry.
Just a moment. The condition says college shall submit undertaking in form of affidavit newly so and so. Waiting board. The admission can only be through KEA.
My lord, if my lord, if the, please come to, my lord, copy. Can I, my lord, persuade your lordships, just look at, my lord, this, the copies.
The conditions in the permission granted, conditional permission granted, they would be applicable. After analyzing the assessment report, matter was placed before 23rd board meeting. On examining the assessment reports also, we identified approved criteria. Decided to grant conditional permission.
My lord, can I request your lords to look at, my lord, the online portal of the KE itself. Before, my lord, I got my affiliation, my lord, it was over. I had no choice.
You cannot then make the admission in that year.
It can't be, my lord. What is impossible of performance, my lord, I can't. Please have a look at this.
Then you cannot make admission in that relevant year.
My lord, my submission to your lordship.
Your admission has to be at least to the 50% seats. At least to the first 50% seats. It can be only through the KEA, no other method is available.
My submission to your lordships is impossibility, my lord, is not, my lord, matter, my lord, which can be, my lord, performed.
The condition on which you are given a provisional permission is that you will make the admission only in accordance with the accepted procedure. Yes, you have you have a permission.
my lord,
But the permission cannot go beyond the accepted procedure. You cannot, then what is the meaning of this entire exercise?
my lord, I understand what is, my lord, falling from your lordship's, but in the fact situation, what is it that could have been done, my lord, I ask myself. Look at, my lord, the my lord, the KEA website itself. Last date, my lord, was, my lord, 21/10. Mop up round, my lord, 27/10. In the light of this, my lord,
Further inform that 15% of the college should submit an undertaking form, ESI, so and so provisions of employees. So further inform that 15% of undergraduate seats of the permitted intake capacity of 100 UG seats shall be treated as all India quota. Counseling of seats under all India quota shall be conducted by the respective counseling authority as designated
admission,
by
no,
the
every
secretary for the academic year 22-23 and counseling for remaining 85 seats, as the case may be, shall be conducted by the concerned counseling authority of the state union territory. Permission of the college stands withdrawn if the college fails to comply with the aforesaid direction of the central government, NCISM, for the all India quota or the students admitted thereunder. It is also informed that the determination of fee, etc., admissions made in violation of the above conditions will be treated as invalid and action will be initiated under NCISM Act and regulations thereunder.
my lord, total number of seats was 68. We have admitted 9. 50%, my lord, we haven't even admitted 50%. 9 students are before your lordships. This honorable court, my lord, division bench has already granted permit with me to, my lord, take up the examination, last examination.
That is
There is an interim order already passed by the division bench, Chief Justice.
hearing this one.
I apologize. It's on my legs in the next.
Yes.
I was on my legs before the next court and I'm sorry for the delay in making it. So
There
far
is no
as,
delay. You're just hearing the senior counsel appearing for the petitions.
yes, your ladyship. So far as the application is concerned, I would still object to any announcement of results or permission to writing of exam, because this matter is very similar to the matter that is being heard by a different combination of this honorable court. And those matters were also to be listed today. However, I'm given to understand that they have now been posted to 14th of February. So this matter may also be heard on merits itself, because clearly the admission has been made contrary to the regulations without counseling, without undergoing counseling through the authority. So, and in contravention of a letter that was issued by the authority saying that these students need to be discharged. They cannot continue their education. So
When was that letter issued?
I will. And this matter is again a matter where where is I was reading that?
Yaudadu.
So the contention is this, if we are not mistaken. If it is after the counseling process of the All India quota as well as the KEA, that the permission gets granted, and for that year, it cannot be operated. Is that so?
There's no issue on
as a matter of fact, there must have been, the college must have approached the court, got some orders at when the permission was. Is that
my
so?
understanding is
Without being included in the seat matrix, it cannot be done is how we understand it.
I will have to verify on whether the conditional permission was granted prior to or subsequent.
Well, it's a part of record.
It's
Page
apologize.
It is all there.
15/12/77.
It says admissions made in violation of the above conditions will be treated as invalid and action will be initiated under the NCISM Act and regulations. Discrepancies, if any, may be immediately brought to the notice of the Medical Assessment and Rating Board for Indian Systems of Medicine. Following requirements shall be fulfilled by the college. Page 77.
Yes, your ladyship.
Paragraph 3. Page 77, the order is on 7/12/22.
2022.
The contention
See, the
is that by
college
the
can-
time all the rounds were over, did you grant such permission at that stage? If the counseling cannot be conducted for that relevant year, how can you grant? Because your order itself says it has to be through AIQ. The All India quota should be through the counseling procedure. The rest of the seats should be through the KEA. After the KEA has finished its entire allotment, please verify whether this is correct.
I will verify on this because this is 2022 and it could, my limited, if my memory doesn't fail me, for that particular academic year, it went on until March 23 counseling rounds. So they had 3 months. But that is my understanding.
If that is so, maybe let them get instructions in the matter.
I will seek instructions.
If as a matter of fact, it is required to be done through the KEA and the KEA counseling, at least some of it was remaining, we don't think there is any ground.
No, only thing is, my lord, KA, I have given to your lordships. In the light of that.
Whether this was, we know, each year it is the dates are extended.
No.
Even this year, we are extending the dates. Every year, dates are.
This they have not extended, my lord.
Anyway, please
Let
get.
her,
I'll seek instructions on that.
Yes, issue notice.
Your ladyship.
So-and-so learned council takes notice for R1. So-and-so takes notice for R2 and R3. Only 3.
There is one more issue here. So the writ petition, the interim order was passed by a learned single judge. And in that I was not made a party, nor was KEA a party. They filed a writ appeal before the division bench. And it was at that time that we became aware of such a matter and we sought impleadment in the matter. And now that writ appeal has...
are allowed. Impleading petitions are here.
Right now it is the writ appeal that is listed at serial number 6.
Yes, so the impleading petitions are here.
I'm only speaking about this matter.
The impleading petitions are here.
Yes, certainly.
Yes, impleading petitions are allowed.
Great.
Yes, please get instructions in the matter. We'll list it to another. If as a matter of fact, it was an ongoing procedure, then you're right. But then otherwise, how do you grant a permission when the entire procedure is over and then tell them you can't, then why grant that permission at all?
I will seek instructions on that.
Yes.
Permission granted after closure of the admission to renew to the benefit only for the next academic.
Let's see.
I'll give, my lord, one more judgment of the division bench of this honorable court, Justice Vikramjit said.
Yes,
Only
14. Great, 14-1. I'm sorry.
14-2.
14.
My lord, admission is on, my lord, the examination is on 18th. Can it be 1 week earlier to the, some date earlier to 14th, if it is possible? If it is possible.
On
7th.
7th.
Today is 7th.
Today is 7th, my lord.
14th.
No.
14th. Because the other matters, the writ appeals that is.
Lord, 14th is a Friday. Please look at it.
No.
Therefore, some.
12th.
12th. Obliged.
My lord, can it be on?
Please get the last dates
Can it
as
be-
for the
Yeah.
that year.
My lord, one request. Can it be on 11th?
11th.
Please, grateful to you.
11th.
Please,
11th.
Yes.
please.
Obliged.
Just get instructions on this.
Yes, I'll see.
Very.
And with regard to the dates, anything that you want to place on record, please have it ready and serve copies also so that.
Certain.
Yes. Mansi Kumar for.
Just to amend the first item. Registry shall show their name in the first. It's not 11.
I represent the appellant.
Recalling.
My lord, this appeal was dismissed for default on 29/10/22. On Saturday, it is purely an error on my part. I did not notice on the special sitting day. So it was dismissed for default.
In the connected matter,
Same
I
matter.
also filed an application.
You have filed affidavit? Affidavit is.
Yes,
filed.
madam.
Yes,
As
in
stated.
my application, my
I have
own
filed my
affidavit is
affidavit.
filed. In my application, I have filed
The
my own
same thing
affidavit.
has happened to my, no, I am the respondent in his appeal. He is the respondent in my appeal.
Good understanding. Orders on I-1 of 22, the common orders. Okay? Word. This will be filed by the council. Balance in both the appeals. Except in the cost show for their absence on 29/10/2022. Order dated 29/10/2022 is recalled. Accordingly, I-1 of 22 is allowed. Bill is restored. List for I-1.
Great.
Delay. No delay. No?
Delay, immediately we have.
Serial number 8 for the appellant in this matter.
Hmm.
I had filed IAS to place on bring on record certain legal airs. There is some delay and abatement has to be set aside. The difficulty was,
54 days.
but the difficulty was we were not informed of the death. As soon as we were informed of the death, we filed the applications. my lords.
Everybody served.
All of them are served.
Third, is the comments made in the affidavit accompanying the IAS. Accepting the cost shown delay of 754 days in time and application to pay. Legal years in this are 4. So, abatement is set aside. The legal years of the author of accordingly, I have 2 of 24, 3 and 4 of 24 are allowed. The appellant shall amend the cost title and file a amended cost title in a period of 1 week. He is granted further week's time to take steps to bring legal years of R3 on record.
Please, I'm ready.
The proposed respondent number 3 in this, my lord. I have been served only on 29th, my lord. I have intimated National Highways Authority. May I request 10 days to submit, my lord?
Is the appellant?
You are respondent number 3.
Proposed respondent number 3, my lord, please.
What do you want to do?
Get instructions.
You need time, madam.
10 days time, my lord. I'm yet to even file wakalat.
I'm for the appellant lordship, proxy counsel.
Serve them copies, you are not served.
Please.
I've been served, my lord, but only on 29th, my lord.
So you appear for only 3 or 192 there?
Please, my lord, only proposed respondent number 3.
Served.
SLAO and executive engineer.
Special Land Acquisition Officer, NHI, AR support.
If I may make one submission regarding that, my lord. 1 and 2 is actually state government, PWD, but National Highways is center and the project has been entrusted to National Highways. So I can't,
For third response.
only for third, my lord.
Third SCGP is request to accept notice for respondent number 192. Appellant shall serve set up.
Please.
papers. Yes. We start 2 weeks.
For the appellant in this case, my lords. My lords, the respondent have filed an application to withdraw the deposited amount. My lords, in this appeal, my lords, I have challenged the LAC award, which is passed by the reference court. My lords, your lordship had directed me to deposit 50% of the amount. I have complied with. Respondent had filed an application to withdraw the amount. I have filed my objections also, my lords. The objections are this, my lords. If I succeed in this appeal, it will become really difficult for me to recover. My lords, how the amount which I have deposited goes to 2 crores, my lords, 2.5 crores. There is no explanation given by the respondent, my lords, as to why they want the amount. Rather, they only say that they have lost their valuable lands.
That is itself is an important ground.
What is your ground in the appeal? Is there any sustainable ground for half?
My lords, in the similar matter, my lords, your lordship had granted an order, my lords, where 10 lakh was directed to be withdrawn. My lords, on the similar same lines, my lords, they may be permitted to withdraw 10 lakh, my lords.
How much you have deposited here?
2 crores, my lords.
2 crore.
Please, my lords.
50% is 2 crore.
Please, my lords.
Where this land is?
Land is situated, my lords. Chammanahalli village, Kasaba Hobli, Madur Taluk, my lords. Mandya district.
Large extent. You are, that is what.
The extent of land?
My lords, the total extent of land is
3 guntas.
17 guntas, my lords. 17 guntas.
3 different lands.
Yes.
Please, my lords.
Each 10 lakh.
My lords.
You have no objection to release each 10 lakh.
No, my lords, in together 10 lakh, my lords.
All 3 different owners.
My lords, 10 lakhs together, 30 lakhs would, it would be really difficult to recover, my lords, in case if I succeed in this appeal.
Which is why we are asking what is the ground for appeal. It is for Bangalore Mysore for broad gauge.
My lords, may I pass on this writ petition order, my lords, which is passed by this honorable.
Two claims, madam. Two claims.
Claim petitions, sir.
Two claim petitions.
How many claimants?
LAC 30, right. It has been treated as a single number.
Three. One is two the first item of property.
So how much they have deposited?
My lords, they have deposited a sum of rupees
2 crores 33 lakhs
85,673.
85,673, my lords.
So different claimants, sir. How it has to be?
My lord, I will submit. Petitioner, respondent number 1, A to D are one category, A to D. And respondent number 2 is different.
Different. What is the extent of A to D? 11 guntas, huh? 190 entire claims combination. What's different survey numbers?
They are adjacent properties. My lords, at page number 35 of the paper book. 35 of the paper book may be kindly looked into. 35, page number 35. Adರಲ್ಲಿ, the claimants number 1 and 2 are entitled to for
entitled to one property, there are two claimants.
para number 3. The claimant number 1 and 2 are entitled for enhanced compensation towards acquisition of 3 guntas each in survey number 659.
Each.
And thereafter, next para, my lords, for acquisition of 7 guntas and 10 guntas respectively in survey number 308 P bar 1, 308 bar P2. Now together as 308.
This is 7 guntas, 14 guntas, eh? 10 guntas. 7 and 10 guntas.
7 and 10 guntas, my lords.
So in each reference you have deposited differently or common amount?
Common amount, my lords, sir.
Because
that's how.
because LAC has been jointly given single number.
Common order was.
That is LAC 38 of 13.
Right, you.
P18 judgment 46 of 13.
38, my lords.
46
LAC 38, my lords.
22. P18 judgment is what is relied on.
Please, my
That
lord.
is
That is
See, I have
46 of 13.
LAC 38 of 13.
That 46 of 13 is also under challenge?
No,
No, my lords, that
No.
was taken as.
no. And to my information, my lords, they have deposited the amount before the reference court pursuant to the executing the award.
That case.
Yes. So that had attained finality, being unassailed.
Oh, my lords, there is a stay which is operating in my favor.
You just say that without making any reference, 10 lakh rupees to each of the claimant you withdraw. We'll consider the appeal, let the records come.
Please, my lords.
It is all right?
Please.
Yes.
My lords, may I request?
Because the
20
acquisition
lakhs,
of-
My lords, sir.
It will become 15 lakh.
My lords,
Give it to your lordships, my lords.
the acquisition,
2 crore amount, we are just giving them 10 lakh rupees.
Please, I leave it to your lordships. I vote on
In a connected matter, reference is the base for determination. That you have already satisfied that award.
it. I'll vote on it.
If he produces that copy, satisfaction of execution, we will allow the appeal only, dismiss the appeal only 1 minute. Right, to understand, we also know.
I'll leave it to your lordships, my lords. Leave it to your.
my lords, acquisition pertains to 2011, my lords. And even today, not even a single paisa has been received by the claimants.
Son, orders on, I have one of them. And also for the respondent applicant, which is the year 2011. Next, last year, the compensations so far. And the present application is moved seeking to prayer, release the amount is deposited. That function for the applicant, oppose the application and submit them. If the amount is released, payments. The appeal. For them to recover the said amount from the agriculturist. And see, seeks to dismiss that. Application, the answers on. The reference for taking note of the judgment.
LAC 46 of
46 of
13.
13.
Exhibit P18.
Market value at rupees
442
square feet and awarded the compensation. The matter requires detailed consideration, hence the interest of justice would be met if we permit the respondent number 1A to D to withdraw rupees 10 lakh rupees, and respondent number 2 rupees 10 lakh.
Also.
During the pendency of the appeal. The reference court is directed to release the aforesaid amount to claimants on proper identification. Accordingly, IA is disposed of. Call for TCR. TCR, but yeah.
Then date may be fixed, my lord, for final disposal.
Oh, finally.
List for final hearing, list week after next.
Date may be given, my lords.
Admission agree.
No, not yet admitted.
List for admission, week after next. All that's it.
Mature.
LIC execution Thursday.
Please, I will. I have also informed my lord, I will get it. And my lords, for receiving the, I think LCR may be required.
The registry is
Order
directed,
sheet may be transferred.
registry is directed to return, send back the NCR to the reference court, and the reference court shall retransmit the NCR once the purpose is served. Once the amount is released in favor of the respondent. 3 weeks out, list after 3 weeks.
Mature.
Appear for petitioner lordship. Raise a week time for a preliminary
The
hearing.
statement is also ready.
My senior not feeling well, lord. Raise a week time.
The statement is ready, my lord. I'll file it.
Please file it.
Yes.
Give copies of
Yes, I'll
copies
give
of.
it.
The learned counsel for the petitioner seeks short accommodation. Learned counsel appearing for the second respondent submits that a statement of objections is ready and will be filed after serving copy to the learned counsel for the petitioner. List next week.
Yes, sir.
Yes, yes, lord.
Thank you. Thank you.
There is a mistake in the ranking of proposed respondent number 3 to 8. I will make corrections in the office, please. IA nalli.
IA for impleading.
IA for impleading. They are the
First one R4.
one of the impleading applicant is no more. I have filed an application to bring the LRs of R4.
That's some correction, office objects. Madilwa.
Illa, I will carry out the corrections in there.
Each time is granted to comply office objection on IA 1 of 25. If office objection.
But I represent the LRs of
complied
respondent
with,
number 1.
issue notice on IA 1 of 25.
Please.
The appellant is withdraw ಮಾಡ್ಕೊಳ್ತೀರಾ? Impleading ಬೇರೆ ಹಾಕ್ತೀರಾ?
Impleading ಬೇರೆ ಹಾಕ್ತೀರಾ ಅಂತ ಕೇಳ್ತಾರೆ.
I will try if it is possible, I will carry out the correction. Otherwise, I will make a fresh application.
Also, the appellant submits that there is a error in ranking of the parties in IA 1 of 16. He seeks permission to carry out the corrections. The said request is accepted. He is permitted to carry out necessary corrections in IA 1 of 16.
ಆಗಿದೆ.
1 week.
And I represent the LRs of respondent number 1 in this matter. There is, I mean, once they come on record, the matter can be decided because it's the case where they are the daughters, they are given equal share. That's the only thing. And a date may kindly be fixed.
Martin, I will do it in probably 2-3 days time. Connected appeal alli, this is the suit filed by the daughters, the claiming partition. Because in view of the pendency of the earlier appeal, 254 of 2009, summarily my suit is dismissed. As against which this appeal is filed.
ಅದರಲ್ಲಿ notice ಎಲ್ಲ ಆಗಲಿಲ್ಲ.
ಇಲ್ಲ ನೋಟಿಸ್ ಆಗಿಲ್ಲ, ಕನೆಕ್ಟ್ ಆಗಿದೆ.
Connect ಆಗಿದೆ, but other thing.
They can take notice.
ಅದು ನಿಮ್ಮ ಮ್ಯಾಟರ್ದಲ್ಲಿ.
I appear for them.
ಅದರಲ್ಲಿ ಯಾರು ನೋಟಿಸ್ ತಗೋಬೇಕು ಹೇಳ್ಬೇಕು ನೀವು ಚಿಟಿಯಾಗಿ ಬರ್ಕೊಂಡ್ರೆ. We will make note of that.
Yes.
ಎಲ್ಲಾರ್ ಸಮ R4 ಇದೆ ಪ್ರಸಾದ್.
ಅದರಲ್ಲೂ certain appellants are no more and application is filed to bring
Ready for disposal, all these things are there. ಏನ್ ಮಾಡೋದು ಇವಾಗ?
And the next week, your lordship, by then we'll try to. ಅಲ್ಲಲ್ಲ.
ಮಾಡೋದಾ ನೆಕ್ಸ್ಟ್ ನಿಮ್ಮ ಮ್ಯಾಟರ್ದಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್
notice ಮಾಡಬಹುದು.
Notice.
ಕೊಡಿ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ದಲ್ಲಿ. Issue notice on IA 1 of 23 to 3 of 23.
we'll file our wakalas for the concerned persons, my lord, so that the matter can be heard at.
Today our undertaking memo,
Yeah.
Wait, my,
the week's time is granted to bring LRs of deceased appellant number 3 on the file. Please. There. 24. Appellant. Sir. LR application is next page. This is the appellant number 3. Their application is to be allowed, no?
No, my lord, no. What happened, my lord, earlier? There is an order.
Connected
The
appeal only.
No,
My lords are asking about the connected appeal.
Connected matter. 13.
Adalli even notice ಮಾಡೋದಕ್ಕೆ order ಮಾಡಿದ್ದಾರೆ ಸಾಹೇಬ್ರು.
I will take notice for
ಯಾಕೆ?
respondent number 1, I think.
One already appellant ತೀರೋಗಿದ್ದಾರೆ. Appellant number 3 has died.
Appellant number 3 is no more.
ಬರ್ಕೊಳ್ಳಿ madam. Orders on IA 3 of 24, 4 of 24 and 5 of 24. Except in the cost shown delay of so days, 1462 days in filing an application to bring LRs of appellant number 3. Unknown amendment is set aside. Legal heirs of the appellant number 3 are permitted to brought on record. Appellant shall amend the cost title and amend the cost title in a period of 1 week.
Nimbralli sir, 2103. It is his appeal, my lord.
Wait.
No, appearance before the respondent number 1
And
to 5, my lord.
Something here and again she will come to make 1 day 2 pages notes she has made it come to myself. For this also 10 times.
I know.
My lord, the memo is filed by the respondent number 1, 3, 4 and 5, A to D, my lord. Not by the appellant. Memo is filed by the respondent number 1 to 5, my lord.
Memo.
We have filed a memo at serial number 2 of the cause list, my lord. That we
Compromise
have filed, it
petition
is not
without-
filed by the appellant.
Compromise petition without,
Compromise petition, yeah.
without the appellant,
No, compromise petition was filed by the appellant number 3 and respondent number 1, 2,
it's a partition suit.
1, 3, 4 and 5. Yeah. It is not possible. We are trying compromise. We are trying settlement with the other parties also.
You can make the attempt and if everybody joins,
Yes,
then
yes, my lord.
once they join,
Yes,
we
ma'am.
can consider.
Yes, my lord.
We cannot consider.
It will not be possible.
Your lordship, I make one submission.
Please
Yes, my
make,
lord.
and if you manage to get them also.
Yes,
then
my lord. We're talking with the others also.
My lord, make one submission, lord. Respond number 5 in concern, my lord, during the pendency of the appeal, respond number 5 is no more, my lord. The LRs of the
I
respond
have
number 5 had filed, my lord. My name may be deleted, my lord. Prithvi Vadiyar, my name may be deleted.
So, only for a file for R5,
R5, we have filed caveat, my lord. During the pendency, R5 is no more.
Appellant is granted 1 week's time to bring legal heirs of R5 on record. Registration
Allah, R5 is already on record, my lord. They have R5.
all these things you are saying.
No, he is saying that he does not.
Send Samir third appearance for R5. And delete the name of Prithvi Vadiyar from the cause list.
Please, ma'am. Oh, bless.
ಏನು ಬೇಡ ಅಷ್ಟೇ ಹೇಳ್ಬಿಡಿ. Since Samir entered appearance for R5, legal heirs of R5, they delete the name of Prithvi Vadiyar from the cause list.
Two books.
Product from where you will bring these books. There is no representation for the nor there is no representation nor the order dated 11/24 is complied. Last chance, week's time is granted. Comply, list on.
Right? Okay. Yes, yes, yes. Very lengthious, father. Yes, yes. Okay.
I appear for respondent number 1 and 2. Lord, it is for 2014, my lord, it has not yet been admitted. So therefore, my lord, at least after taking the interim order, let these formalities be completed and matter be.
IA 1 of 24 not pressed.
Not pressed. When comes for the appellant, submits that we will not press IA number. One of the state is submitted, IA is rejected.
Maybe we posted for admission, my lord.
Not admitted,
Not yet admitted. Because compliance took time. So
File ಮಾಡಿದಿರಾ? Print ಮಾಡೋಣ?
madam, ಇಲ್ಲ admission ಗೆ we have submission because there are 3 my lord titles, 2 title suits the appellant has already lost. So therefore, my lord, repeat it. These are continuation. No, I said I have got submission.
List for admission.
Yes, next week, my lord.
Yes.
Great.
Week after next. Date ತಗೊಳ್ಳಿ.
One date may be fixed, my lord. Any date may be fixed. Any date may be fixed.
27
Oh, great, great.
Appear for appellant, Your Honor. Previous counsel has expired.
Name of matters. Earlier, the student of this name was an expert in.
I am for the appellant, Your Honor. Previous counsel has expired in 14/9/2023. I filed the fresh wakalat along with the memo and affidavit, Your Honor. Yes, Your Honor.
Steps for R3, R4, R5.
The matter is going to be settled, Your Honor. I want to withdraw the case. The ಹಾಕಿದ್ದೀನಿ, Your Honor. CS Prakash, Your Honor. ನನ್ನ ಹೆಸರು CS Prakash. PS Guruprasad ಅಂತ. He expired on 14/9/2023. I have filed the bar council claim name and as well as death certificate.
They will report the settlement,
Yes, Your Honor. The only thing is, both the parties are age 90 plus. Court ಬರೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. Withdraw ಮಾಡಿದ್ರೆ the only the catch is I may lose the court fee.
Settle outside and memo ಕೊಟ್ರೆ withdraw.
Yeah, I'll place the memo. Maybe pass over, I'll place now itself, Your Honor.
Outside. Instead of entire court fee, limited the entire as per law. As per law. That entire we don't know. You have to check that and make.
Yes, sure. Maybe next week I'll report it, Your Honor.
Speak.
They want, we can do one thing. If you want, we can refer the matter to mediation so that a mediation agreement will.
I'll take instructions because both the parties are 90 plus.
You understand? Oh, then it will be a problem.
Maybe pass over, Your Honor. I'll take instructions. If they are not, if they're willing to forgo, I'll.
Next week you will give a date.
Yes.
Yes, Your.
Date. 18.
Much obliged, Your.
But then the bleeding will have to be like. Absolutely, I agree with you. Absolutely. Absolutely. You know, saying any district cases would be tendencies would be reduced and then you won't have to go through the process. Yes.
It may post on Tuesday, my lord. I'll file my objections to the IA, my lord. Tuesday or Wednesday.
It might not be required, my lords, for the reason, my lords. For what fell from my lords was that last time, that the joint inspection report will be set aside, and because it has happened in my absence, I'll go, my lords, let them conduct a joint inspection report in my presence. And that is all I crave for, my lords.
I'll
What
file
do
my
you say?
Tuesday, it may post, my lord. Once I'll file the objection, it may be.
It appears to be a very fair submission.
No, my lord.
You can't use again. This is all.
Tuesday or Wednesday, I'll file, my lord, my objections to the IA, my lord.
He's arguing on merits.
No, my lord. In writ appeal. Tuesday, I'll file. Monday, I'll serve the copy and immediately I'll file, my lord. May post on Tuesday.
Filing of objection to IA for stay. Don't worry with the IA for stay. This is all there is to it. He says that this also, there'll have to be an inspection in his presence, not behind his back. That is
Please, my
all.
lord. Please, maybe dispose.
Tuesday.
Please, my lord.
It can be.
It can be disposed. We'll fix a date for a joint survey on his presence.
Very well, lords. Yes, yes, my lords. There's a writ petition and a writ appeal, my lords. My writ appeal was dismissed for, my writ petition was dismissed for the reason that there's an alternative remedy. But my lords, I challenge the jurisdiction of the ground. That's the first matter. Then the other matter was, building cancellation happened, and that was also on same grounds, my lords. Based on the joint inspection in which I have led to both of this order, my lords.
The petition also, please. With appeal number so and so. This appeal is preferred against the judgment of the learned single judge dated 21/4/2022 in WP number 8044 of 2020. The learned counsel for the appellant submits that the show cause notice, which was under challenge, had been issued on the basis of the notice and report of the Lokayukta, which is produced as Annexure G and Annexure K, which was produced as Annexure G and Annexure K. Full stop. It is the specific case of the appellant that Annexure G and K reports were without due notice to him, and that the proceedings were being initiated and continued on the basis of the reports without any further site inspection being conducted. The writ petition 10302 is filed challenging the notice dated 12/3/2021 issued by the third respondent, which is produced as Annexure G, and the letter endorsement dated 18/5/2021, which is produced as Annexure J. The learned counsel for the petitioner submits that orders are to be passed, taking note of the explanation referred by him at Annexure H, and after conduct of due inspections with notice to him. Having considered the contentions advanced, and in view of the materials on record, we notice that the Annexure J and K reports, G and K reports, Annexure G report, which was under challenge in writ petition number 8044 of 2021, was one prepared without notice to the petitioner, and the inspections, if any, conducted were conducted behind his, were not conducted in his presence. In the above view of the matter, we are of the opinion that a joint inspection is to be conducted with notice to the petitioner as well, before any further action can be taken in the matter. In the above circumstances, we dispose of the writ petition as well as the writ appeal, directing the respondents to conduct a joint inspection with notice to the petitioner and to proceed further in the matter only on the basis of the joint inspection report as duly served to the petitioner. The respondent shall take necessary action in accordance with law, untrammeled by anything stated in Annexure G report, and on the basis of the findings in the joint inspection to be conducted as directed.
Great, my lords.
In correct matter, we need to pause that.
Yes, my lords. The building commencement certificate, my lords, is a subject matter of challenge there. Both, my lords, both. And in the writ appeal, my lords, that is produced at annexure H, my lords. In the writ appeal.
The consequential notices issued
Yes,
which are under challenge in WP 10302 of 2021 shall also stand set aside, awaiting further action in terms of the joint inspection report
Yes,
as directed.
I'm grateful, my lords.
For respondents 1 to 3.
Serial number 920, I appeal for the appellant, my lord. Today, my senior is slightly unwell, my lord. I request for a date in the next week, my lord.
Every time it is going on like this. Only
What is
notice,
the matter?
notice issued by the BMTF to inquire into the complaint made by the respondent number 5, my lord, for appearance. He had questioned that in the writ petition. Main ground is the term of BMTF had expired. That has been extended. Now the government advocate has also produced documents to show it has been extended.
It is in force.
It is in force. The government advocate has produced documents also regarding.
Pray for a date in the next week, my lord.
Next year, W at page 120 is the notice issued by the BMTF. Yeah, W, page number 120, 120, yes. That was questioned in writ petition.
The only notice you can go, always give a reply.
Yeah, that
For
is
the
what
purpose
learned
of
think consider-
inquiry regarding property.
yes, regarding encroachment of the
Yes,
public.
therefore you have to submit your reply. Why is a show cause notice being kept under stay?
There, yes, my lord, there is an interim order operator.
Please, Appellant's Counsel, please enlighten us. Why is it being kept under stay? It is only a show cause notice. Right law.
Yes, my lord.
We leave open all your contentions and also your right to challenge in accordance with law, if any adverse order is passed against you.
Yes.
No, my lord, I request for a date, my lord. We'll assist the court in the next date, my lord. Senior is slightly unwell, that's.
Yes, sir. No, we will not keep such matters pending. If you have a case, we will quash that if they don't have a jurisdiction. But you should argue. When you will argue?
13th, my lord.
When you will argue? Next week, any date, Monday, Tuesday?
13th, my lord. Next week, 13th. On 13th, my lord.
Last chance.
Please, ma'am.
Yes, adjourned at the request of the Learned Counsel for the appellant. List on 13-2 as a last chance.
Please.
If arguments are not addressed, the matter will be disposed of on merits. Right?
Yes, my lord. Thank you.
11 day was there or not? You should be able to.
Yes,
You have a
copies.
memo or not?
Copies good. ಇಲ್ಲ ನನಗೆ ಕೊಟ್ಟಿಲ್ಲ
ನಮ್ಮ ಫೈಲ್ ನೋಡ್ಬಿಟ್ರೆ ಅವತ್ತು ಹೇಳಿ.
ಪ್ಲೀಸ್ ಪ್ಲೀಸ್
Even if all it is the same is correct. Even if this is correct. Yes.
My lord, I am appearing for the appellant.
My lord, office had raised an objection with regard to the pecuniary jurisdiction. My lord, the matter pertains to, my lord, land acquisition by the first respondent, that is Special Land Acquisition Officer, for the benefit of second respondent. My lord, the compensation awarded was on a lower side. Therefore, my lord, a reference under section 18 was made, and my lord, the lower court, my lord, has awarded 40 lakh rupees per acre, 46 lakh 69,000. So that amount itself, my lord, sufficient for this court to have jurisdiction.
Already last time you made that.
Yes, please, ma'am.
You are rejected.
Yes.
You are now what you are paying, you have to pay court fee on that. How much claim you are making now? On that you have to pay now. Based on what he claims.
I have also filed a memo, my lord, of calculation.
Once we about rupees 104 lakh per.
I have paid, my lord, court fee also. I have filed
Paid court fee on the enhancement.
Please, I have filed a memo to that effect on 30th January 2024. I have valued it, my lord, 57 lakhs.
He has paid.
No, he has not.
I have paid, my lord. I have.
He has paid for the reference court amount. Whatever reference court amount is enhanced on that you have paid, no?
On 57 lakhs, my lord. May I request my lords to kindly take the memo, my lord, for a moment.
Oh.
A memo, I have filed it on 30th Jan.
104 lakhs is your claim.
Please, my lord.
104 lakhs is your claim. Enhancement.
Yes, please.
104 lakhs
Yes,
per
please,
acre.
my lord. What was enhanced by the lower court was, my lord, 46.
669.
Please, my lord.
So,
On that, my lord, I have paid.
reducing 4669 from 104. Is that how you've calculated it?
No, my lord.
No.
May I just read the
Yes.
last paragraph of the
Yes.
memo of calculation, my lord?
Yes.
For the purpose of jurisdiction before the honorable court,
Hmm.
the subject matter of the appeal is valued at rupees 57 lakh 30,829. Accordingly, a court fee of rupees 1 lakh 94,971 is paid as per the provisions of Schedule 1, Article 1. So whatever was, my lord, awarded,
What is the extent of the property?
my lord, 1 acre, my lord, 1 acre, 14 guntas. Exactly 1 acre, my lord. 1 acre.
Only 1 acre.
Yes,
It's
please, my lord.
easy. It's easy to calculate.
Yes, please, my lord.
Relation with 30%,
Amount he has to pay, no?
so yes.
Whatever he claims,
Hmm.
whatever you are claiming on that, you have to pay the court fee.
My lord, whatever was awarded.
What is awarded?
Please, my lord, before the appellate court, that is under challenge, my lord. Of course, my lord, my matter, my lord,
What is your claim on that? You have to pay the court fee.
my lord, my claim was, my lord, 1 crore per acre. 1 crore per acre.
On that you have to pay. 1 crore 4 lakh rupees you have.
If that is your claim, is it not on that you must pay the court fee?
But actually what was awarded on that time, my lord, I have challenged that.
How can you?
I'll just verify that, my lord, in that case.
No, we just thought maybe you are calculating on the basis of whatever is the difference.
Difference, yes.
But that
2 weeks time is the request, 2 weeks time is that. Comply of subject.
Right.
Just say that.
not on what is being
This is another
granted,
judgment.
definitely not on what is granted.
His Lordship Justice Ravindra judgment is there. How you have to calculate the court fee in land acquisition matters.
Please.
Go to scrutiny bench straight away. They will give you.
Please, I'll verify that. I'll learn.
Clearly.
Please. Publish.
Writing memo for deletion of respondent code 4.
See that 1 lakh rupees, and that first 2 lakh rupees used to pay the court fee. And we need to give a judgment saying that even a court fee is paid. Yes, sir, we can award higher amount and recover that fee.
That is what we do.
That is
here.
judgment, some judgments are there.
That is how we
But
do.
we can't exempt now in a beginning stage.
Respond number 4 is dead, not even in the, before the trial court. I am deleting from the past title. Memo is filed. It is a case filed by the corporation, finance corporation for recovery of money from the borrower. Now that has been, miscellaneous has been dismissed not on the ground of limitation. Can maybe
Yes.
consider,
Memo.
notice to the respondent.
With the memo,
Grand counsel for the appellant has filed a memo. Seeking dispensation of issues of cities to R4. Who is allowed issues of to R4 is dispensed at the discretion of the appellant. Issue notice. Permissions of R5 ಏನಿದು?
R5, no. R4, not rather, Murthy is stated. No, R4 is now, she becomes
Sir,
R4.
after subjects, week's time is granted to comply other after subjects. ನೀವು ಮಾಡಿಲ್ಲ R5A ಮಾಡಿಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿ.
ಮಾಡ್ತೀನಿ ಅದನ್ನ.
ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ. Week's time is.
Sorry, my lord, he's still on his legs in Kotal 2, my lord, my senior counsel. Still on his legs in Kotal 2, my lord. This matter is going on.
So the next week, Lord.
except for this.
Good.
Absolutely. Exactly.
If you scan CPC, it
Hmm.
will be disposed of in 2 weeks' time. They will be. Criminal offense, scheme offense, they have scanned. ತಾವಿದ್ದೀರಾ ಸರ್ ಅದ್ರಲ್ಲಿ 26 ಅಲ್ಲಿ ತಾವಿದ್ದೀರಾ 26 ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಇಲ್ಲ ಸನತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ನಮ್ದು ನೆಕ್ಸ್ಟ್ ಬಂದಿದೆ ಮೇಡಮ್
It's a list of authorities. Will file. Hmm.
request this next week.
Hmm. Okay. Money suit.
ಏನ್ ಮಾಡೋದು ಇವಾಗ ತಾವು ಒಂದ್ ಫೋನ್ ಮಾಡೋದು ಮಾಡಿದ್ರಾ ಫೋನ್ ಎಲ್ಲ ಮಾಡಿ ಏನ್ ಫೋನ್ ಒಂದ್ ಮಾಡಿ ಒಂದು ಯಾರು ರೆಗ್ಯುಲರ್ ಬರ್ತಾರಾ ಸರ್ ಅವರು?
One and three have remained expired.
Even the trial court also, they all remained ex parte. And money suit was dismissed on the ground that this barred by limitation. I have filed my written submissions also on 20th. I will try to get him for phone. Let me say.
Final hearing without him also, it is not good.
I will next week, my lord, I will try to get him.
Sri Varadaraj are all that for the appellant. Also Sri. For the appellant, there is no representation for the respondent number 2. Awaiting his presence, list on signs. Next on date court get.
Or in this month itself, you can do it.
24.
Okay.
And that's why I also maintain health. At least in
For the appellant in this matter, my colleague appears in this matter. It is for the respondents to argue. Mr. Naganand had addressed detailed submissions. Colleague was on VC. From yesterday, it had come to today.
Yes.
Let's may pass it over. The respondent's not here.
Okay, next man.
51.
I appear for the
PRT.
I appear for the petitioner, my lords. Difficulty today, my lord. Senior counsel has some difficulty. Any date next week, we will argue.
That's the third respondent. My lords are aware. This is the matter where I am the successful option purchaser.
Any date next
More
week,
than
my
10
lord.
years this has gone on, my lord. I've met my lordship's hand.
Any date next week, even Monday, my lord. Senior counsel has some difficulty. He is in a part heard in the Supreme Court. Any date next week. I apologize for any inconvenience to my friend as well. Any date.
My lord, if it may be fixed at 2:30 for one day, may be taken up, subject to this. Court's
The request of learned counsel for the petitioner. Please start. 32.
Grateful, my lords.
Who is senior counsel appearing?
Apologies, my lordships.
Senior counsel is appearing.
Dr. Sondi, senior counsel, Dr. Sondi.
My lord, the next date, even if senior counsel is not available, let the matter be.
Your senior counsel is very tough opponent for him. Sondi has some. Is Sondi, Dr. Sondi is.
3-4 times.
Has been.
And the auction purchaser, I am stuck after having paid more than 10 crores.
I will not seek an adjournment on the 13th, my lordships.
13, sir.
Grateful.
Yes, LAC Upper Tunga project.
Prashant. Prashant's colleague. ಅಲ್ವಾ MRC Ravi colleagues sir ಅಲ್ಲ
MRC
ಬರಲ್ಲ ಇವರು
ಪ್ರಶಾಂತ್ ಟೈಮ್ ಏನಾದ್ರು
ಪ್ರಶಾಂತ್ ವಕಾಲತ್ ಏನ್ ನೋಡಿ ಅವ್ರ ಹೆಸರು
ಬೇರೆ
ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ಬಿಡಿ ಅವ್ರ ಜೊತೆ ರಾಮಚಂದ್ರನ್ ಬರಲ್ಲ ಇವರು retirement they join the profession.
After some time they. Oh, that. Yes. Distance someday.
Here, here. Registration, so the name of PR Shantha Ramchandra K for the appellant.
Land acquisition.
My lord, in this matter.
Acquisition.
I'm sorry, my lord.
Acquisition.
Yes, this is
You are for the
acquisition.
claimant.
Please,
Yes.
I'm for the claimant.
Mm.
This case, my lord, is in respect of lands that were acquired in 1990 for the Mangalore International, Mangalore Airport.
Mangalore.
Mangalore, my lord. Mangalore Airport. And the crux of this matter is that the action and inactions of the land acquisition officer has resulted in a gross violation of the rights of the appellant in as much as this, my lord. If I may just submit a brief list of dates.
Yes.
So same number, appeal. The preliminary notification was issued on 1/1/1990.
Yes.
Preliminary notification was issued on 1/1/1990.
Hmm.
16/11/1992 is the award. On 16th April 93, the appellant, on the side of the appellant, objections are filed and a reference is sought.
Hmm.
Reference is not made.
Hmm.
96, he passes away. 97, my lord, I file an application before the court under section 18(3)(b) asking for a reference. An order is passed on 12th October 2009. Next page, my lord. An order is passed in that LAC directing them to make the reference. They don't make the reference. Then I approached this honorable court in a writ petition in 2014. On 11th, on 3rd March 2014, I filed that writ petition. And on 11th March 2014 is when they finally refer the matter. So they refer the matter 24 years later, my lord. 1990 is a preliminary notification. 92 is the award. 2014 is when the reference gets made.
When you make the application for reference on 2796.
93, my lord, I make the objection. My initial application to the SLAO is in 93.
Okay.
Please.
17/4/93.
Yes, my lords.
After which you approach the court seeking the reference
97.
only on 12/10/2009.
My lord, before that, in 97, I approached the court under 18(3).
18(3).
In 97 itself.
Within time.
Please. And in 2009, the order is passed. Even thereafter, they don't pass. Even after that,
The High Court direction reference.
after the High Court, after I filed the writ petition, my lord, then when the matter came up before this, before the High Court, then they make the reference in 2014. So therefore, there is a delay of 24 years in making the reference. Or if we take it as from the award, 22 years in making the reference. The award that was passed, not only that, my lord, there is a second part to this. As per the award, they gave me an amount of 250 rupees per cent. That was the amount that was granted to me in 1990. Please, 1990 notification, 250%. In the award that I have now challenged, it has been increased to 7,000, which also I am aggrieved with. But in any event, my lord, 250%, please, my lords. 250%. Even that amount till date is not deposited. It has not been paid to me. I have filed, my lord. In fact, the amount that I have in fact mentioned it in my list of dates. In 11, if my lords would just see for a moment, 11th March 2014. Total amount awarded is rupees 6,77,008. Then, my lord, the total amount deposited is only 1,41,000. That is not even the interest. And even this amount that was awarded by the reference court of 7,000, which they have not challenged, even that amount is not, has not been dispersed. I have, my lord, that executing proceedings are underway, but I am only bringing to the attention of the court the manner in which I have been deprived of compensation at every single level. And these are factors. It is my respectful submission that would have to be taken into consideration when my compensation is being calculated. That, my lord, is even the recent judgment of the Honorable Apex Court, which looks at what happens when there is such a long delay in finally ascertainment of compensation, in calculation of compensation, how that is to be done.
That case, amount was not passed.
My lord, I'll just refer to those judgments. There are a series of judgments.
Here you have a 12, 15, 23, you have a
Please,
interest, no?
but my lords may consider 1990 preliminary notification, 1992 award,
Change the date of preliminary notification to this date, huh?
to the at least to the date of reference, my lord. That would be my submission. I will attempt to convince my lords on this, but at least to the date of reference, because it is not on me that this took place. I have followed. I'm sorry, my lords.
For interest.
My lord, that's what the Honorable Apex Court says.
But we can't do all. Writ is all right. Huh?
My lord, the Honorable Apex Court has said that whether in these cases, whether it would be fair to put me back only at the compensation as I was as per 1990, and whether interest itself would suffice to take care of my otherwise what I would be entitled to. This is what the Honorable Apex Court has also looked into. So this is one part of my submission.
All which side? An appeal, can we consider such? Whether it is permissible?
It is my respect. It was my endeavor to convince my lords that my lords could. It would be my effort. That would be my endeavor. That is one part of my submission, my lord. I'll just very quickly summarize my submissions. So firstly, my lord, it cannot be that the date of notification, I mean, the date of calculation can be 1990. Given that all this has happened and there has been an active delay, it is not that I have kept quiet. It is not that I have not done something to ensure that a reference is made. I have done everything that is possible. I gave the letter. I approached the competent court. There was an order that was passed. Then I approached this honorable court. There is a delay of 24 years in that regard. It is my submission that might be considered.
Sent me the judgment. I don't know whether date of PN is pushed for purpose of maybe some because of litigation or for the reference, I think the seeking reference is pushed.
For seeking reference because
the notice was
yes,
notice was not served.
Never
because of the
served.
litigation,
That
it
is
was
a-
a dispute.
It was only
From
for
that
seeking
date, it should be
reference.
considered made.
Not this. This we have not done.
Yes.
Yes.
My lord, so that is one. That is my first submission. I'll just summarize my grounds in brief, my lord. Secondly, my lord,
Your contention is that when, even if the award is passed,
yes,
if compensation is not paid, then the latest judgment of the Supreme Court would come into play is your contention.
my lord, there are two judgments of the Supreme Court. One is the latest judgment of the Apex Court. The other one is in Udo Das, my lord. In Udo Das, where the Apex Court has held that if there is a delay in not only payment of compensation, also in the whole process of calculation, adjudication, there's a delay. Then the subsequent developments that take place have to be considered while looking at calculating the compensation. So that's the other judgment that I am relying upon. I have 2-3 other contentions, my lord. I'll go to that after I finish this, perhaps. And these are all facts that I have placed before the learned reference court. In my evidence, I have led evidence. None of these are contested in any way. And it was all before the learned reference court. The first judgment is the latest judgment, my lord, of the Honorable Apex Court in Bernard Francis Joseph. If I may trouble my lords to go through some of those paragraphs, which I'm relying upon. From paragraph 36, my lord, that's page 20, ink page 20. That's when the discussion on this aspect starts. At paragraph 36, it can thus be seen that this court in the aforesaid case observed that normally compensation is determined as per the market price of land on the date of issuance of the notification regarding acquisition of land. But there are judgments of this court where in similar situations, instead of quashing the impute notification, this court shifted the date of the notification so that the landowners are adequately compensated. This court directed the compensation payable to the landowners be determined as on the date when possession of the land was taken by the respondent therein, that is 19th February 2003. Paragraph 38, my lords, looks at the judgment in Tukaram Kanna Joshi, that the right to property is now considered to be not only a constitutional or statutory right, but also a human right. My lord, from paragraph 43, my lords, page 26.
Yes.
Paragraph 43, Article 300A of the Constitution provides that no person shall be deprived of his property save by authority of law. The state cannot dispossess a citizen of his property except in accordance with the procedure established by law. This court in the aforesaid case of Vidya Devi observed that in a democratic polity governed by the rule of law, the state could not have deprived a citizen of their property without the sanction of law. It was further observed that the state, being a welfare state governed by the rule of law, cannot arrogate to itself a status beyond what is provided by the Constitution. Recently, this court in the aforesaid case of Ultratech Cement Limited observed that the government is a welfare state, ought to have proactively intervened in the matter with a view to ensure the requisite amount towards compensation is paid at the earliest. It was further observed that the state cannot abdicate its constitutional and statutory responsibility of payment of compensation by arguing that its role was limited to initiating acquisition proceedings. Then, my lord, it looks further at those judgments. If I may take my lords to paragraph 48. It cannot be gainsaid that the appellants herein have been deprived of their legitimate dues for almost 22 years ago. It can also be not controverted that money is what money buys. The value of money is based on the idea that money can be invested to earn a return and that the purchasing power of money decreases over time due to inflation. What the appellants herein could have bought with the compensation in 2003 cannot do in 2025. It is therefore of utmost importance that the determination of the award and dispersal of compensation in case of acquisition of land should be made with promptitude. We find that in the present case, the appellants were required to knock at the doors of the court on a number of occasions during the period of last 22 years. The appellants have been deprived of their property without paying any compensation for the same in the same set period of last 22 years. As already discussed herein above, the appellants have purchased the plot in question for construction of residential house. Not only have they not been able to construct, but they have also not been paid any compensation for the same. As discussed here and above, though right of property is no more a fundamental right, in view of the provisions of Article 300A of the Constitution of India, it is a constitutional right. A person cannot be deprived of his property without him being paid adequate compensation in accordance with law for the same. In the present case, it can clearly be seen that there is no delay which can be attributed to the appellants in not getting compensation. But it was on account of the lethargic attitude of the officers of the state, KIDB, that the appellants were deprived of compensation. Only after the notices were issued in the contempt proceedings, the compensation was determined by the SLAO on 22nd April 2019, taking guidance value prevailing in the year 2011 for determining the market value. My lord, although it is a fact that this matter was in respect when the acquisition itself was challenged. Certainly that's the case. And in that, the Honorable High Court had directed the SLAO to redo the compensation, shifting the date of notification. Subsequently, that was challenged before the Honorable Apex Court. The Honorable Apex Court holds that the SLA cannot do it, but the High Court can do it. But the principle that is there, that when there is so much delay that is caused, if my right to fair compensation is a right that I have, and if I'm going to be given in 2024, compensation calculated as per 1990, and this entire period of delay has been caused by the inactions of the SLAO, then can I be put in that position? That would be the principle that is brought out by the judgment of this Honorable Court in this case. So although while I do see that in that particular case, they were challenging the notification, here to the principle remains, my lord, that would be my submission. The next judgment that I'm relying upon, my lords, in fact, looked as the plights of land losers in this whole process, where their lands are acquired and they have to go through for several years for getting their compensation. Not for a moment, if you were to see, the SLAO fixed the amount at 250 rupees. Even if we see what the Honorable Reference Court has said, Reference Court says 7,000 rupees. But whether it can be only at those rates in 1990, when even for my reference to take place, it took 24 years because they failed to do that. Would that be a rightful thing for?
Twenty-three says that. Compensation goes back to from that date.
The enhanced compensation goes back to the
7,000 goes
Yes,
back
yes,
to the
yes. It goes
And-
back to 1990.
and therefore you will get the enhanced compensation.
Yes.
The solatium and interest from that date.
Yes, Manoj. But the question that I would ask myself is, would the interest and solatium, yes, from that day, actually be fair compensation, given these facts and circumstances, where there has been a delay that has been caused of 24 years by the inaction of the state authorities? Would interest suffice and interest compensate? And that is what also is looked at, if I may just take my lords to the other judgments that are there.
The acquisition, but directly to pay additional 2% interest on what is provided. I don't know how is there.
Is we are only concerned about how the appellate court.
Please, my
in
lords,
these proceedings can consider. If there is any case where that has been done, please place it before us.
Please, my lord, I will look a little bit further into this, but I only want to say one thing, my lord. Even before the reference court, I had made all of these, I had specifically said all of this.
The question of law may not be important before the reference court nor the appellate court.
Yes.
We should point out the evidence to show that it is 7,000 or 700, whatever is incorrect, because 10,000 is there on that day.
Yes, I understand what my lords is.
Not appreciated properly, then we can appreciate that in the first appeal.
Please, my lords, I
appeal proceedings where the appeal is
Yes, of the
is a continuation of the reference proceedings.
Please.
Therefore, in that,
Scope
what
of the
the
appeal.
scope of the power we are exercising is also completely different.
Please, my lords. In fact, if my lord would see the order of the learned reference court, how did the reference court arrives at the amount of 7,000 as compensation? The reference court, my lord, has, what had happened, my lord, there were a series of, there were several cases that had been filed in respect of lands that had been similarly acquired.
Yes.
In respect of some of those lands, the reference court had calculated the compensation at 8,000. That had been challenged before this honorable court. This honorable court had increasing the development costs from 20% to 30%, had reduced that compensation payable from 8,000 to 7,000. That is the reasoning of the learned reference court in arriving at the figure. If my lord sees the order of the reference court, my lord would see that all of what I am submitting before this court, I have said over there. From page 20, my lords.
Evidence you have produced to determine, show the market value. What is the evidence you have produced?
My lord, evidence I have in fact produced sale exemplars. I produced 2 sale exemplars, which
Take us to the High Court order. Where is that? MFL.
the judgment in the of this court, my lord. 7,000. Okay, I have only one copy of that judgment. I'll just pass that on. What the reference court has relied upon. In fact, subsequent to this judgment and subsequent to the award passed, there was another batch of matters similarly placed, where again the reference court had passed an order for 8,000, and this court in fact upheld that order as 8,000. I have produced it along with my list, man. Along with my
For the
reference court order. Yes,
It is referred in para 22.
please. And with my list, which I have with my authorities that I have produced today, the last judgment is the judgment
MFA 3528.
Yes, please, my lords. In this 8,000 was also was awarded by the reference court and upheld by this court, and they have also accepted that at page 138.
The acquisition is same notification. Huh?
Yes, my lord, same notification for the runway, second runway and terminal of Bajpayee International Airport.
Yes.
Notification date is same.
Yes, my lord, it's the same.
Same village. Yeah?
Same.
1910-1989.
My lord, it's 89, but it is that is the
This
date
is
of the
the same.
publication. This is the date on which it was at.
That's all.
1/1/1990 is
Around
that.
24/2/92. This is 1611.
Yes. It's for the same second runway, my lord.
Yes.
Second runway and terminal of Bajpayee International.
According to you, how much reference court order you have granted?
I'm sorry, my lord.
Claim petition before the reference court.
My claim petition took into account that the date of the date of compensation must be taken, it must be shifted to 2014, the date on which reference was made. And for that 22 years, it should be there should be a consideration that is done. And on the basis of that, I had produced sale exemplars for the period of 2005, which in fact has been accepted because in fact my own land, one more portion of this total portion of my land was subsequently acquired in 2005. And in that, those sale exemplars which I had produced here were accepted by the reference court, and a compensation of 23,500 was awarded. That was upheld by this honorable court, and which they have accepted. 2005, my lords.
In a 2005 acquisition.
Yes. And the reason I produced that is because by the time my reference took place, it was so many years had passed. So I am not placed equally along. My submission is yes, in respect of certain other property owners who have lost their property, an amount of 7,000 or 8,000 was fixed. But I stand on a different footing, but because several other things have taken place, which has placed me in a peculiar position. And those aspects have to be considered. My lords asked me about what in terms of the powers of the appellate court. All of these aspects I have placed before the honorable, before the reference court. All of this I have placed before the reference court. And in fact, if I may just trouble my lords to look at Udodas, page 41. This is in fact it arises out of a reference. In this also, there is a delay of almost 20 years. If I may just read the facts, my lord, paragraph 6. Wide notification dated 17th May 1990 under section 4 of the Land Acquisition Act, 162.5 acres of land situated in village Patti Musal Musalmanan was notified for setting up a housing project in Sector 12, Sonipet. This notification was followed by declaration under Section 6 of the Act on 16th May 1991. The collector rendered his award on 12th May 1993, awarding a sum of rupees 2 lakhs. On a reference under Section 18 of the Act to the additional district judge, compensation was enhanced to rupees 125 per square yard for the land behind the ECE factory situated away and on the left side of the Sonipet Bahalgarh road, and rupees 150 per square yard on the right side abutting the aforesaid road. In arriving at these different figures, the reference court held that the land on the left side did not abut the road and it had therefore less potential. The High Court in first appeal further enhanced the compensation from rupees 125 to rupees 135 for the land on the left side and to rupees 160 from rupees 150 on the right side on the principle applied by the reference court. The present set of appeals at the instance of the landowners have been filed impugning the judgment of the court below. Paragraph 17, my lords. At page 44.
Yes.
Although in the present matter, sale instances around or near about the date of notification of the present acquisition are available, yet these cannot justify or explain the potential of a particular piece of land on the date of acquisition, as the potential can be recognized only sometime in the future, and it is open to a landowner claimant to contend that the potential can be examined first at the time of Section 18 reference, the first appeal in the High Court or in the Supreme Court in appeal as well. We must also highlight the collectors as agents of the state government are extraordinarily chary in awarding compensation. And the landowners have to fight for decades before they are able to get their due. We take the present case as an example. The land was notified for acquisition in May 1990. The collector rendered his award in May 1993, awarding a sum of rupees 2 lakhs per acre. The reference court, by its award dated January 2001, increased the compensation to rupees 125 per square yard for the land of the road behind the EC factory, and rupees 150 per square yard for the land abutting the road, which would come to rupees 6 lakhs 5,000 and rupees 7 lakhs 26,000 respectively for the two pieces of land. This itself is a huge increase via the collector's award. The
Yes,
please. The High Court in first appeal, by its judgment of 24 September 2007, enhanced the compensation for the two categories to rupees 135 and 160 respectively, making it rupees 6,53,400, rupees 6,74,400. In other words, this is the compensation which ought to have been awarded by the collector at the time of his award on 12th May 1993. This has, however, come to the landowner for the first time as a result of the judgment of the High Court, which is under challenge in this appeal. In other words, a full 17 years from the date of notification under Section 4 and 14 years from the date of award of the collector, on which date the possession of the land must have been taken from the landowner. Considerately, the Act also provides for the payment of the solatium, interest, and an additional amount. But we are of the opinion, and it is common knowledge, that even these payments do not keep pace with the astronomical rise in prices in many parts of India, and most certainly in North India, in the land price, and cannot fully compensate for the acquisition of the land and the payment of the compensation in driblets. I also think South India also, my lord, it's not very far. The 12% per annum increase, which courts have often found to be adequate in compensation matter, hardly does justice to these landowners, whose lands have been acquired, as judicial notice can be taken of the fact that the increase is not 12 or 15% per year, but is often up to 100% a year for land which has a potential of being urbanized and commercialized, such as in the present case. Be that as it may, we must assume that the landowners were entitled to the compensation fixed by the High Court on the date of the award of the collector, and had this amount been made available to the landowner on that date, it would have been possible for them to rehabilitate their holdings in some other place. This exercise has been defeated for the simple reason that the payment of compensation has been spread over almost 2 decades. In this view of the matter, we are of the opinion that the landowner is entitled to say that if the compensation proceedings continued over a period of almost 20 years, as in the present case, the potential of the land acquired from him must also be adjudged, keeping in view the development in the area spread over the period of 20 years, if the evidence so permits, and cannot be limited to the near future alone. We therefore feel that in the circumstances, the appellants herein were fully entitled to say that the potential of the acquired land has not been fully recognized by the High Court or by the reference court. My lords, if my lord sees this judgment, along with the first judgment that I had read out, where when the latest judgment, where the Honorable Supreme Court has said that 22 years of delay that is caused by authorities, and compensation is not adjudicated, is not calculated, and has not been paid, mere payment of interest would not suffice and that would not result in fair compensation. In fact, my lords, the other judgment, which at page 47 in Kolkata and now we're in 24, my lord. 25.
It's true.
Please.
The 1990 compensation
Yes.
was awarded at 25,000 per acre. That
Yes.
you would have got 83,250 as compensation for
Yes.
3.33 acres.
Yes.
And then we are talking about Bangalore. So when you say 3.33, it is 3 acres, 33 cents.
Yes.
Not guntas.
Yes.
So, and with 30% solution, that comes to 1,08,225. It appears that 1,57,000 odd is already in deposit.
1,40,000 something, my lord.
1,41,174.
1,40,000, 1,000.
Now well, where do we get that 6,77,000?
I'll just, my lord, I'll just verify that and I'll make my submission on
If
that.
that is so,
Yes.
then you are right. If what has been awarded by the SLAO in 1992
Please,
has not been deposited, then you have a point.
please, my lord. That I will just
Even
point
so,
to that.
Now,
Sorry.
whatever is the enhanced compensation, that enhanced compensation takes solatium and interest from the date when it becomes due. That is under the 92 award. From that date, you get the entire interest. This proposition
Please.
does not appear to be supported by the law, because the law specifically says that it has to be what you're entitled to is the value of the land as on the date of notification. Then it is to protect these delays that happen on account of the process, that you are also entitled to interest at rates prescribed by the law from the date when it becomes applicable. And if it is modified at any point, then it becomes the date when the land value is to be calculated, that remains stationary. But to compensate for any delay, you're entitled to interest from that date onwards. If they commit any delay in the matter of reference or in the fixation of the compensation, for whatever reason, you're entitled to interest from that date. The enhanced compensation, solatium and interest from that date.
My lord, this
is the scheme. So to say that the potential development should also be taken into account goes against the law that as we understand it.
Whether interest that is payable for the entire period would suffice in actually compensating for and actually ensuring that what is being paid is fair compensation.
If, as a matter of fact,
yes,
what is awarded by the SLAO is not paid, you have a case we can consider. If what is awarded by the SLAO is paid, and there is a delay in the reference and in the refixation of the compensation, whatever is the refixed compensation is referable to the date of the notification, and you get interest from it is the scheme. If you cannot say that it is not in accordance with law, because that is what the law prescribes. In all cases, to give a person a better benefit would be to deny it to others. How can we pick and choose acquisitions and say that in this case, you're entitled to something more than the land value as on the date of the notification, which is why is there such a law? It is so that it should be applied in all cases, and that a person losing land in one acquisition is not discriminated against as regards somebody who loses land in some other notification. There must be some formula to it. Otherwise, what is the result? Result is complete discrimination.
In
Please
this-
tell us whether,
Yes, I will verify that, my lord. I'll verify that whether on,
if
I'll in
you-
fact maybe make a calculation and I will submit it before this court.
what exactly was the amount awarded by the SLAO? Was
Yes.
it deposited? If that was deposited, that was paid to you. Then if that was not paid, if your contention is that what is awarded in 92 was not paid, then we'll consider the order.
I'll look into that and I'll make my submission in that case. Apart from this, my lord, my other submission is in respect of the potentiality of the land. Because this,
Potentiality of the land can we consider as a question?
yes, my lord, because
Hmm.
there are minerals in this land and that there is no valuation made insofar as the minerals are concerned. I will
You're-
address
you're-
both of this. I'll verify this
You
and
had
I'll
made those
address both. Yes,
contentions before the reference.
and in fact, that has been admitted by the SLAO. In his evidence, he says that there's laterite in this land, and he admits
Yes.
that. But I will answer my lord's question insofar as the payment of compensation, so that I can make my submissions clear on that. On the other aspect, I will also look into whether this has been looked at in an appeal, whether this aspect has been looked at, my lord. I'll also do some research on that front.
Is because it appears to be, on the face of it, it appears to be against the settled position of law.
But my reading of the judgment of the Supreme Court in Udodas's case is that the reason that we need to look at future potentiality is because interest would not actually suffice. The scheme of the act, it says that how does one arrive at market value? And then it provides for interest, provides for solution, provides for everything else. But what it seems to say is that when there is a large delay in actually calculating the compensation.
In that case, this contention that the initial compensation was not paid is wrong, does not appear to be there at all.
I'm sorry.
Even your contention that you're raising that
Yes.
the initial compensation fix
Yes.
has not been paid.
Yes.
Such a contention is not there.
Yes, it's not there at all.
Not there.
So in that
It
way,
is only the procedure takes a long time.
yes, the procedure takes a long time, and therefore the reason I'm making the submission is also that it is not only even if you were to say for a moment otherwise, even if we don't shift the date of the notification for a moment, then the subsequent sale exemplars which have been produced by me, which otherwise one would have said, no, we cannot look into this because it is not of that day, it is of a subsequent period. That could not have been completely negated if we are to look at future potentiality. So let us take for a moment, if I don't say that we shift the date on which we consider when the date of the calculation of compensation. Suppose we are not on that. If we were to say, my lords, that the future potentiality of that land was required to have been considered. And I have produced sale exemplars. I have produced 2 sale exemplars of 2000 and 2005, which have not at all been considered. So that potentiality could have been considered.
2005 sale exemplars, can they be considered as?
Yes.
Applying
Applying this de-escalation. That aspect. So I will look into this and I will answer, my lords. I'm sorry, my lords.
In 2005, what is the sale consideration?
Around
What is the
30,000.
value?
30,000.
30,000.
Please, 30,000.
8,000.
I'm sorry, my lord.
8,000.
Now it is 8,000.
Yes, 8,000.
De-escalation applies for 15 years. De-escalation.
Yes. 2004, my lord, was 30,000. The sale date is 12th November 2004 for 30,000. I'll answer my lord's question if my lord.
We'd like to hear you also on this.
Yes,
We'd like to hear you also on this.
yes, ma'am. There is a delay, but all other writ appeal, MFA, that is 8,000 and 7,000.
Here is a case where, that is a case where the award was of the year 2014.
Yes, ma'am.
Apparently, the reference has been made within a reasonable time.
Yes.
This is an award of 2020 because reference was made only in 2014 after the land losers approached the court and after contempt.
They are entitled for interest on that.
Will that do is the question. That exactly is the question she's raising. Whether interest will do or is she entitled to something further. These judgments that she has referred to also, please tell us whether there is anything to the contrary after that by a larger bench. on the very same question. Yes.
Next week, my lords.
When do we-
Ready?
Next week on Tuesday or Wednesday, my lords would give me. I'll just make a list, that calculation.
Give it after a week,
Very well.
not in the next week, because we've
After
listed very.
Very well.
many.
My lord, may I request for the week of 17th, that next week I'm not there, 17th, 18th or 19th, any of those days.
Dates are there.
Between 17th to 21st, 21st, very well, most grateful.
Hearing for respondent, my lord. You look at the time.
Yes.
My lord, senior engaged in the court hall 28, kindly 1 week.
Yes,
Next week. Next week.
that's also with the P.
Even 34, my lord.
34 is been adjourned.
It is informed to you on the. It was told
34,
that-
I am ready, my lord.
No, it was told that they have informed you and taken time.
34 has been adjourned, stating that you have been informed.
I'm sorry, I'll not enter into such.
Apparently not.
Very short point involved in this case, jurisdiction of the labor court. Whether it is Mangalore or Mumbai, that's the only point.
Well,
Anyway,
it has been listed on at 13th, 13-2.
13, very well. I'm okay.
It is informed.
I appear for the line.
Yes,
Not matter pertaining to Lord proceedings initiated under PMLA.
yes.
Hmm? I'm told that Lord, there are other writ appeals which are pending before this honorable court in respect of Lord's
Very
similar
same.
issue. The other side, your lordship may have this matter next week, Lord. I am told by other side, Lord, that writ
There
appeal.
are other matters we listed along with them and hear them.
Yes.
What is the issue you're raising?
Lord, the issue is, my Lord, the Prevention of Corruption Act is inserted as a scheduled offence in the year 2009.
Yes,
Lord, the earliest offence is said to have taken place prior to, my Lord, 2009. Lord, notwithstanding that, my Lord, I should bring it to your lordship's notice as an officer, my Lord, that the coordinate bench has held that, my Lord, it is a continuous offence.
okay,
Disproportionate asset.
yes.
If, my Lord, I am transferred from Bellary to Bangalore to other place, I have amassed the wealth. Lord, though I have amassed wealth in the year 1990,
You're continuing to enjoy it and therefore it is a continuous.
therefore, it is continuous. Is the, my Lord, the finding of coordinate bench. Another judgment of, my Lord, this honorable division bench is, my Lord, at page 302 annexure N, which says, my Lord, not. However, my Lord,
the order at annexure N is tested, Lord, there is an interim order that, my lord, it shall not be treated as precedent. My lords will find the order at, my lord, page 310. ಇದು precedent ಆಗಿ treat ಮಾಡಬಾರದು ಅಂತ, my lord, there is an interim order. Therefore, my lord, even I cannot rely upon the judgment rendered by the division bench in Lord annexure N. Para 10 and 11, Lord, at page 310.
It is seen from the records that all offences allegedly committed by the writ petitioner were earlier to insertion of the provision. Therefore, the enforcement case information.
May I read, my lord?
Writ petitioner cannot be prosecuted for the offence alleged as they are not scheduled offences under the PMLA.
Yes, my lord, the Prevention of Corruption Act is inserted as a scheduled offence,
With
my lord,
effect from June 1,
on 1/6/2009. The offence is alleged to have been committed, my lord, prior to that period. This court, my lord, has held that,
Where does it say that it should not be treated as precedent?
but this order is tested by, my lord, Enforcement Directorate before the Honorable Apex Court.
This
And
is confirmed.
there is there is an interim order to the effect that this shall not be treated as precedent for other cases which are pending. Lord,
It is being considered by the Apex Court, you mean?
Lord,
Therefore, this proposition has to be, now it has to be decided by the
Lord,
Apex
it is, I would say, my lord, it is.
Money you have kept in the pocket,
Please.
even after adding also it is continued, huh? That way. You should know.
That analogy, my lord,
Yeah. Or day after also you're carrying that money, hence a continuation of offense.
my lord, yes, my lord, the learned judge says that, my lord, suppose, my lord, if I have acquired property in the year 1994,
Yes.
I will sell it in the year 2006 or 7. Then, my lord, I will purchase one more property.
It goes on and on.
On and on. Therefore, it is a continuous cause of action, is the, my lord, tenor of that judgment. Therefore, my lord, I cannot.
Yes. We'll have to, do you have the numbers of the other cases?
And I permission.
Please get them.
Read up a entry model is there. Huh? It is going on there, huh? Proceedings. Good. Come aram se.
We'll list it along with the connected.
Initially, not, there is no interim order. No, I not after we also.
Yes, we'll list it along with the connected matters.
Connected matters, no numbers.
I don't have numbers, but I'll furnish to the report.
There is no representation for the respondent. List 2 weeks. 2 weeks we are, please, possible, please. Okay.
28th, kindly have it at 2:30.
One of us can come and sit here.
We'll do it.
Happy for the
We
appellate.
can take notes. The bench is not there at 2:30.
Kindly have it on Monday, my lords. Much obliged.
Monday.
Very well, very well.
Monday at 2:30, my lords.
2:30, there are other matters.
Monday. Much obliged.